Hello, hello. If you have a question about your immigration case, go ahead and pop it in the box below, and I'll do my best to answer as many questions live that I can during the time that I have today, okay? And if you want to schedule yourself for a case evaluation, it does not matter to us what state you live in. We work with clients all over the United States. It does not matter to us the way, how far you are, because we work with clients virtually to make your life as easy as possible. So if you do want to schedule a case evaluation, give us a call at 212-248-7907. So I'm going to start off with answering a question today that a lot of people have been asking, which is, will filing an immigration case help protect me in my stay here in the US? And this is a very important question that is on the top of people's minds because of the fact that we have this new administration coming in who is decidedly and very publicly anti-immigrant. So will filing an immigration case protect you? So let us talk about this. First of all, let's talk about the fact about why you would want to file an immigration case in the first place. The reason why you should be wanting to file an immigration case is to protect your rights. There are a variety of types of immigration cases that may be available to you. And first of all, in order for you to find out what you are eligible for, the first step is always to do a case evaluation with somebody who understands the case types, who can ask you the right questions to see what you might qualify for, and then can offer to you some possible solutions. So the number one reason why you should be filing an immigration case is to protect your rights, because you may be eligible for something, and the only way to get that relief is to actually apply for it. So what happens when you actually file an immigration case? Well, during the process of your immigration case pending, it is going to, in many, many cases, give you a variety of benefits. In some cases, number one, filing a case may put you in a period of authorized stay, depending on what you file. And when you file certain applications, such as an I-485 or other humanitarian applications, during the pendency of this case, it can put you into a period of authorized stay, so that if you were to happen to get picked up by ICE or get arrested, you can use this to show and to ask them to release you from bond, to release you from detention, or to allow you to have more time to process your case, okay? So that's number one. Number two, in a lot of cases, you may be able to get certain protections, such as a prima facie determination, a work permit. And a work permit, as you know, is going to be really, really important in the next few years, because a work permit is going to give you, a federally accepted ID. If you're able to pull this out, then it also shows to officials that you have a case that is pending, and they're less likely to get you arrested and put into ICE detention. But of course, getting an immigration case filed by itself is not going to be 100% protection against getting placed into removal proceedings. But the bottom line is that when you have certain applications that are being processed by immigration, this is going to give you a little bit more of a tool to say to them, hey, listen, I understand that you put me in removal, but I have this case that is pending, and therefore, will you please allow me some more time to process this case, or release me on bond, or whatever it is. It's going to give you a little bit more leverage, okay? So these are the reasons why you should be fighting for your case. You should be fighting for your immigration rights and fighting for your ability to live in this country securely and freely, okay? 212-248-7907. Now, another question that I have gotten recently is the fact that if you want to travel outside the United States, can you do so with your current case, right? And that is also going to depend on what sort of case you're applying for, and whether or not it gives you the ability to apply for a travel document, an advance parole, and also whether, even if you do have an advance parole, if it is the right time to travel, or if it is safe to travel. Number one, if you do already have an advance parole, my number one advice is to always discuss with your attorney's office about whether or not it is safe for you to travel. for the most part, most people don't have problems returning to the US on advanced parole, but advanced parole is not a 100% guarantee that you'll be allowed back in. And of course, you're going to be asked questions when you return. So you really want to discuss with your attorney first before you travel about whether it is safe to do so. Now, there are certain cases through which you may not be able to apply for an advanced parole until you get approved, such as for cases involving a T visa or a U visa. So what are your options if you really need to travel, but this is all that you qualified for, right? Well, you really have to make a decision, right? If you only qualify for a T visa or a U visa and you cannot get an advanced parole until after your case is approved, you have to weigh the pros and cons about, hey, should I at least try for this case or should I just leave the country right now, right? Because in many cases, even if you have to travel, you may not have an option except to just wait for your case to get approved, okay? But of course, there are certain expedites that you can do if you do have certain family emergencies or other humanitarian emergencies. You can always ask for the U.S. government to expedite your case, okay? And getting your case expedited can then give you the ability to request travel documents, okay? All right, go ahead. Let's go ahead and look at some questions that we have over here. Hello to everyone. Hi, Jazzy, Ramal. Let's see. Tell us something about the new bill to reunite families. The bill is dead. There's nothing more to say about that right now. Let's see. My question is for someone. My brother came many years ago without inspection. He got married and his lawyer sent an I-130. Is he okay? From Sylvia. Sylvia, that is a great question. What happens if you entered the country without inspection, but you're now married to a U.S. citizen, but your lawyer filed an I-130? Well, is that the right way to go? Is that the right thing to do? Is your case going to be okay, right? So if you enter without inspection and you are married to a United States citizen, and you want to get your green card, your pathway is not going to be necessarily that simple because you're missing something that is really important for. You're going to be missing that entry with inspection for your green card application. So in many cases, a lot of people, what they will do, a lot of lawyers will help you file for something called a waiver, an I-601A provisional waiver, which you can only file after your I-130 is approved. And filing an I-601A waiver requires for you to leave the United States in order to do your inspection, basically get your interview done outside the U.S. and come back to the U.S. with an inspection on your passport, and then you get the green card. However, the majority of people do not want to leave the U.S., right? Who wants to leave the U.S.? Who wants to risk family separation? Who wants to risk being denied out of the U.S., right? This happens to so many people. So many people leave for their consular interviews and find out that they have more inadmissibilities, that they might be ineligible, they might get denied because of a permanent bar or fraud or misrepresentation, even though they have the I-601A approved. And that is a horrible feeling, to be outside of the consulate, to be in the consulate in Mexico or wherever you are and get a denial, and then you can't come back in for several years after that, and your spouse, your kids are in the US. So our goal here in this office is to help people find ways to fix their status without having to leave the US. So what are the most common ways to be able to help you fix your status in the US without having to leave? Well, number one, if you are married to a US citizen, if you're married to a US citizen and you're suffering problems in your marriage, and these problems can be a variety of things. If your spouse doesn't like for you to go outside, they're always accusing you of cheating on them. If they make fun of how you look, they tell you that you're fat or that you need to dress better. They constantly make fun of your immigration status. If they constantly threaten to divorce you, or if your spouse constantly threatens to call immigration or the police on you, then these can be signs that you might qualify for a case called a VAWA self-petition, which allows you to then do a green card application in the US. And for this, you do not need to have an entry with inspection, and you also do not need to leave the US in order to get a green card if you are approved, okay? So that's number one. And I really, this is something that is very important for people, because especially when you're doing the waiver process, it could take, nowadays it's taking like 5-6 years to do that. And on top of that, you still have to leave the US. So when you do a VAWA self-petition, it also gives you the ability to apply for a work permit and a travel document at the time that you file, okay? And if you have the permanent bar, it may still be possible to help you get your green card through the valid self-petition, especially if you left the US or you were deported from the US because of problems with your spouse, okay? And number two, then the second best case that I love to look at for clients so that they don't have to leave the US is something called a T visa. And the T visa is something that we are all talking about a lot more these days. Pardon me. Pardon me, I'm getting over a cold. Now, the T visa is going to be for those of you who have worked for somebody who has taken advantage of you. And who of us here have not worked for somebody who has been an abusive boss? And this is particularly important for those of you who are undocumented, right? When you're undocumented, there are a lot of people who will take advantage of that situation. If you're undocumented and your boss knows you don't have papers, they can sometimes, get you to accept less than optimal working conditions. But that's not just it. If your boss is causing you to do work that is unsafe, they're not giving you the protective gear, they make you work many, many hours. And on top of that, they don't pay you what they say that they're going to pay you, right? So for example, if you took this job and you had agreed that your boss is going to pay you $500 a week, but then you work 70 hours and then you get a paycheck or you get cash of only $300 and you go to your boss and say, hey, what happened? I thought you agreed that you're going to pay me $500. And then they say, well, you have to accept this because you're undocumented. You have no choice. If you don't accept it, I'll ruin your name. I'll make sure you can never get a job again, or I'll get you in trouble. I might call immigration on you. And then when you're in that situation and you keep working for that person because now you're afraid of what they're going to do, then that can be a situation where a T visa is also a really good option, right? And for those of you who are married to a US citizen, you don't have a legal entry and you don't want to leave the US, if this has happened to you, then this is something to look into, right? And there are a variety of other situations where a T visa can arise, including if you were in a relationship with somebody, right? If you're not married to a US citizen, right? If you're not married to a US citizen, or you're not married at all, but you were in a relationship with somebody, or you are in a relationship with somebody who is treating you like a servant. They're constantly making you do all the work. They make you get up at all times of the evening to cook for them. They get physically violent with you if you don't have your lunches packed or you don't have the house cleaned a certain way. This can also constitute something that is called labor trafficking, okay? And there are a couple of other cases that you can look at, but they're not as common for people. So for example, if you do not have a legal entry, but you have been in the US for a long time, since at least 2000, let's say, and you had a relative file for you or an employer file for you before April 30th, 2000, then you might be protected under something called Section 245I, adjustment of status, okay? So either way, if the bottom line is that if you were told that the only way to fix your status is by absolutely having to leave the US, it is always a good time to get a second opinion to make sure that every single option has been looked into for you. And we here at the law firm Moumita Rahman, we want to uncover all the stones, and we don't want to leave any stone unturned in your immigration journey. Okay. We do case evaluations over the phone from Tasha. I applied my green card in March 2023 with an I-360 approval. USCIS asked me for a medical exam. I submitted the medical exam in October 2024. How long do you think it'll take to get approved? I'm from Galyan. Galyan, I think within about 6 months, you should hear some information. What happens if your divorce is not finalized, but you need to file for AOS from LCBI? LCBI, okay, that is really interesting. What happens if you're married to a US citizen, but your divorce is not yet finalized and you want to file for AOS? Well, number one, if you have already filed for divorce and you're no longer living with your spouse, filing for a joint green card application is no longer a good idea, because in order for you to do a successful green card application, you have to be in a marriage that, where you want to show that it's still continuing, right? Although technically, in order for your green card application to be approved, you really only need to show that your marriage was viable at the start. Immigration is not going to like it if they see that you've already filed for divorce, obviously, right? Because then they're going to say, well, we're not going to be able to approve it because by the time we approve it, you're going to be divorced, right? So what happens though, if you did file for divorce and you don't have a green card yet? So one thing I would ask you is, well, what happened, right? What happened during the course of your marriage that caused you to file for divorce, right? Were you suffering those sorts of problems that I've spoken about frequently? Your spouse controlling, they're making your life miserable. They're always constantly harassing you because of your ethnicity or where you're from or your immigration status. They constantly put you down. They cheat on you. They make you feel like everything is your fault. When these things happen, these are not really as normal as people have been taught. And these can constitute what is called extreme cruelty inside immigration. And if you got married to somebody who's a citizen, you suffered these sorts of problems, you never applied, and you're about to get divorced, you may still be eligible to do something called the self-petition. So give us a call, okay? 212-248-7907. Queenette Inaboya, should a person be worried when you're in a bona fide marriage and you send in the RFE? Queenette, no. So why do people get RFEs in immigration? People get RFEs for all sorts of reasons. We always take care to file very, very strongly put together cases, but sometimes it is almost like they get everything and they don't even look through the evidence. They just automatically send out an RFE, right? Sometimes the officer is rushed or they don't want to look through everything. Sometimes they're looking for something very particular. So if you get an RFE on your case, it's not always the end of the world. You just have to do your best to respond to it. Samantha, hello, my love. How are you? Nice to see you. I'm sorry, everybody. I'm still getting over being sick. Okay. Lori, I received a prima facie. How long until I get a work permit? Lori, you will probably be getting your work permit within about 5 to 6 months after the prima facie, probably sooner. So good luck and good job. Ash, hello. Thank you so much. You're my client. Hope we're doing well. Your firm does an amazing job. Thank you so much, Ash. Really appreciate your words. Mo Abdos, I got asylum approved last week. When can I apply for a green card? From Mo. That is a great question. If you have been approved for asylum, first of all, congratulations. It's not really that easy to get approved for asylum. But if you have gotten approved for asylum, congratulations. You will be eligible to file your I-485 application after 1 year of your approval. So look for the approval date on your notice. 365 days from that, you can file your I-485 application, okay? And when you apply for a green card through asylum, it takes a little bit longer. It takes roughly 1.5 years to 2 years, okay? I'm 48 years old, U.S. citizen. I have my dad here without any inspection. What can I do for him now? From RE478. RE478, if you have a father or a mother here who is undocumented and who does not have a legal inspection into the United States, give us a call, 212-248-7907, especially particularly for our parents who have been here for 20, 30, 40 years. One of the biggest cases that we like to look at for parents is actually going to be called the T visa, which is going to happen, if your father had any sort of job where he was doing any sort of manual labor, if he suffered any sort of racism, discrimination from his boss, unfair labor practices, not getting paid properly, being discriminated against, being threatened in any sort of way, especially, when you're in this country for that long, there's no way that your employer doesn't know that you're not undocumented, right? So the sad reality is that a lot of employers take advantage of that. So give us a call. Also, if you are a parent who has been here for 20, 30 years or more than that, you're undocumented and you do not have a legal entry into the US, one of the other cases that I really like to look at is a VAWA application. And we just got 2 green cards approved last week for parent VAWAs. I think we got one this week as well for a green card. And what is a parent VAWA application? Let me just take a sip of water and I'll get right into it. Okay, so a parent VAWA is one where you need to especially if you have, if you have multiple children or any children who are at least 21 years old, they're U.S. citizens, And they, we know you love your kids. We know you love your kids. You care about your kids. All parents love their kids, no matter how harshly the kid can be with them, right? So the key is, if you are the parent of a 21-year-old or older US citizen who is constantly just nasty with you, right? You are constantly sad over how they treat you. They make you cry over how they treat you. They call you names. They don't let you, they don't treat you like how they should respect mom and dad, right? They might call you names. They might tell you, why did you come here? You need to go back to your country. They might use you for your money. They might make you feel guilty all the time. They might even get aggressive with you, right? They might throw things around in the house when they're upset. Take your money, take your car, take whatever, break things in the house. These sorts of problems are not normal. And if you're the parent of a US citizen who treats you this way, then it might be time to look into something called a VAWA application, because this can also help you get a green card without leaving the US, even if you do not have a legal entry. And many people are afraid to do this because they're afraid that it will harm their US citizen child. But it is simply not true. It's a private case. It's a confidential case. There's no harm or risk to your child. You have to think for yourself as well, because it is time to protect yourself, and it is time to get that stability in the US that you have worked so hard to get, especially after seeing your children grow up and you've done your best with them, okay? So for those of you with parents who are undocumented, who don't have status yet, these are the two cases that I love to look at. And of course, if your parent has been here that long, you should ask them, have they ever had a relative who has filed for them, a brother or a sister or a parent who became a citizen who filed an I-130 for them, or did any employer ever try to help sponsor them? Because if that's the case, depending on when that happened, they may also be able to do something called Section 245I adjustment of status, okay? Can I add my kids to my I-130 if it's approved already? From Gina Kenya. Gina Kenya, if your sponsoring relative is a US citizen, then your kids would need their own I-130. How long after marriage do I have to file a green card before I get in trouble? From Coco. Coco, you can file for a green card the day that you get married to a US citizen. However, if your relationship is also new, then you're gonna have to work harder to prove that it's a bona fide marriage. So people ask all the time, when is it safe to file for my green card after I get married? There is no timeline. However, you have to do the math yourself, right? If you met 5 days ago and you get married 6 days later after you meet, and then you file your green card 7 days later, yeah, it's not gonna look that good. But if you've been together for a long time, if you've been together for 6 months, a year, you get married, it doesn't matter. Just go ahead and file your application, okay? And of course, the best thing is always to do a case evaluation to make sure everything's okay. 212-248-7907. And Anna Reyes, I hope you're still there. You have a good question. My fiance crossed 3 times and was caught 2 times. Other than that, no crimes. We have a child. And what are his options? So Anna, if he crossed 3 times and was caught 2 times, there's a possibility that he might have something called a permanent bar. And for anyone who has a permanent bar, again, one of the cases that I love to look at for permanent bar is the T visa. Sometimes the VAWA can also help in certain cases, and also the U visa if you have been the victim of a crime. But of course, the U visa takes a very, very long time. Okay, but Anna, give us a call, 212-248-7907. Do you help someone get out of immigration hold from Moreno? Moreno only if they're a current client right now. We're not accepting cases from the from non-clients for that. T visa is approved and have advanced parole. Can you travel outside? From Mitch. Mitch, generally speaking, if you have advanced parole, it should be fine. But again, you should be talking to your lawyer before you travel to go through all the scenarios, okay? Sue Swayze, the section is called Section 245I. I like India. Luis Carmen, I'm your client. The I-485 was sent in July. And now that USCIS is requesting the medical exams, would it help if I do the exams now or wait until they're requested? Luis, it's better to wait until they request it, because if we send it, like the new requirements to send in medical exams is just for the cases filed as of last week. If you filed your case before then, it is still a good idea to wait until the request for evidence. Otherwise, things will get really mixed up. Can a C1D visa holder get a green card through marriage? From Sorab. Sorab, no, you're not eligible to adjust here. You would need to leave the US to do processing outside. However, if you do VAWA or a T visa, those could be options to get a green card without leaving. Do you help unmarried people from Dr. Nephew? Dr. Nephew, yes, I do. Absolutely. You do not need to be married to give us a call. Khalid, Malik, my wife denied filing an I-601. Can I file? If your I-601 has been filed, you can always file a second time. There's no prohibition to filing another time. Can I travel while my VAWA is pending with my combo card? How safe is it going to be? From Bober. Bober, I know that in my office, especially once the administration comes into office, we are advising all clients to halt travel and not do any travel, even if you have advanced parole, because we do think that it's going to get a little bit more. There might be travel bans. There might be increased questionings done by CBP. Who knows? So I think it's good to wait to see how things play out first before you travel. Sylvia, you're very welcome. Thank you. Will the Trump admin be able to deport people who are in withholding of removal? That's a good question. If you have withholding of removal, it's already been decided by a judge. So that's a relief that's already there. And again, it's underneath the INA. So if you've proven the INA is not changing unless Congress changes it, and the president cannot change it, okay? So I think if you have withholding of removal, you should be fine. I'm a citizen getting married to my fiance. Our relationship is real. Does he have a chance to qualify? From Lillian Jeanette, and especially, so whether he has a chance to qualify is always going to depend on how he entered the country. So if he entered with a visitor visa, then that's going to help a lot. If he's been here for this long, again, everything depends. If you're doing a marriage case, everything is going to depend on what sort of evidence you send. And also, if you do get called in for an interview, how you respond to questions during the interview stage, because that is really important. The USCIS officer is number one going to be looking for your credibility, your demeanor, and also how much documentation you have. Okay. So Lillian from the two sentences that you wrote, I think it should be fine. But you can give us a call, 212-248-7907. Applying for VAWA, but my ex filed for annulment. Can I still request spousal support? Can annulment affect my VAWA and my request for spousal support for K-1 visa? From Miss Gowne. I cannot answer any questions about spousal support because I'm not a family law attorney. I only do immigration. However, if you're filing for VAWA and your spouse files for an annulment, you need to fight that annulment, because an annulment, if the annulment goes through and if it's approved, then it can basically really, it can disqualify you for VAWA. So, sometimes people will file for an annulment by themselves, but if you especially file for an annulment, then you're killing your ability to do VAWA. So if you do have a contentious divorce and your spouse files for annulment, you have to hire a lawyer. You have to fight that, okay? Annulment is not the same as a divorce. An annulment is going to basically, once it's granted, it basically makes it as though the marriage never happened. So if that's the case, then you can't do VAWA or anything else with that. But if you already have an annulment, then we can look at some other case type options for you, okay? 212-248-7907. Thank you for sharing the live, Veronica. I submitted an I-130 when I was a green card holder, and now I'm a citizen. How do I update? From Jemmy, you can actually write a letter to the service center and give them proof of your U.S. citizenship and ask them to upgrade your petition. I'm an international student. I want to stay after my OPT. What options do I have? From Alejandra. Options for students are pretty limited unless you can qualify for some sort of work visa like an H-1B. Your time may be up. the most the most common ways for people to get married or to see if they might qualify for some sort of humanitarian case. What is, Sahil, my boss is not paying 8 months salary, please advise. Sahil, it's time to give us a call. If your boss has not paid you in 8 months, it's time to look into why. And this is something that a lot of employers do. They'll say, oh, I'll pay you next month. I'll pay you, I promise. Or business is not good, just wait, I'll pay you when I can. Or just keep working, I'll sponsor your green card. It's actually like fraud, right? Like they're getting you to keep working for them through fraud, and this can qualify for a T visa, okay? And 8 months working without pay for 8 months is unholy. That's really bad. I also wonder what else your boss is saying to you. So give us a call, 212-248-7907. Can an H2 visa get married to a U.S. citizen and adjust status from Lake Sala? I don't remember the particulars, but usually you should be able to. You might have to get some waivers of privileges and immunities signed. But you do need to have a case evaluation, okay? Our office is located in New York City, and we work with clients all over the U.S. What is the process for my employer to sponsor me? I currently have DACA from Jasenia. Jasenia, if you have DACA, anyone here who has DACA who wants to have their employer sponsor them, there are 2 critical questions that you have to look into. Number 1 is, how old were you when you got your DACA, right? How old were you when you got your DACA? And the second critical question is, do you have a legal entry to the United States or not? So if you have more than 180 days of unlawful presence, then you would need a waiver of unlawful presence to get your visa, basically, because you may or may not need it. However, it's commonly needed, especially if you're looking for an immigrant visa. And the reason why your age at the time of getting DACA is so important is, if you get DACA after age 18, every day that you don't have DACA after age 18 is going to be 1 day of unlawful presence. So if you have more than 180 days of that, then you can trigger something called a bar to reentry of 3 to 10 years, depending on that. And if you are getting sponsored by your employer, it's important to remember that DACA is not a status. So you cannot do a change of status inside the US, and you would actually need to leave the US in order to process your visa application. And depending on how much unlawful presence you have, you may not be able to return to the United States. You may need a waiver, and for the waiver, you would need either a citizen or green card holding spouse or parent for that waiver, okay? Number 2, we also have to see, whether you have any other inadmissibility, right? Like, do you have any fraud? Do you have a permanent bar? Anything like that? Because that can also affect. So the process for your employer to sponsor you, it's really going to depend on what they're sponsoring you for, but that's not the important part. The important part is, do you actually have an ability to get your status through your employer with DACA here right now anyway? Some people can, and other people will have problems. What happens to T visa applicants prior to August 28? Because people are now getting bona fide decisions. Are applicants before August 28 at a disadvantage? It's from Square Circle Press. I wouldn't say that you're at a disadvantage. Not everyone is getting a bona fide determination. The government is still not really clear with its processes yet. We're getting some letters here and there, so it's not really organized. Your advantage is that you applied earlier, so your case is in line for a decision sooner than anybody else, okay? If you have any sort of criminal history, we always advise to not travel on advance parole, because that's just opening up a can of worms that you don't want to get into. Joint I-751 filed in September 23, not approved yet. I now want to file for a waiver, still waiting for a final decree in 4 months. Can they approve the joint I-751? If they do that, what can I do? So Moumita, Katansi, and anyone else who has already filed an I-751 joint with their spouse, but now your marriage is falling apart. You may be separated. Maybe you got divorced already, maybe you're not living together, or maybe you're suffering abuse. Especially for those of you who are not living together or who have filed for divorce, my recommendation is to take action ASAP, because if the government approves your joint I-751 before you notify them of not living together or of needing to file for a divorce waiver, then it can adversely affect your future, because what the U.S. government might say is that you did not disclose that you're no longer living together, and they may accuse you of obtaining your joint I-751 approval through fraud. So you don't want to do that. So the minute that you separate from your spouse, if you have a tier resident card, you already filed your I-751, it's time to contact an attorney to get the waiver filed ASAP, or to notify USCIS somehow about that, okay? 212-248-7907. And we have dealt with lots and lots of complicated I-751 applications, including for people who already had their I-751s denied, people who got put into removal proceedings for getting an I-751 denied, people who needed to file for various waivers. So this is something that we love to work on, okay? If you have a complicated I-751 case, if you think that you can't apply because your 2-year card expired years ago, think again. There's no deadline, okay? 212-248-7907. Anbu, great question. Hey, Anbu. Anything that you're expecting under the next president for BAWA or T visa? Anbu, I think that everything is going to take longer. I think that we might get more requests for evidence, and we might see them do some funky things like start requiring passport photos out of nowhere. Like we already saw a couple of things happen last time, like they started rejecting applications for having blank spaces. So we just have to, those are the little things that we expect to see that we're going to have to deal with as it comes. It's hard to predict exactly what would happen. So I would just say that it's best to just take every day one step at a time. Especially, I know there's a lot of anxiety in the community right now about what's going to happen to all the cases. Let's be clear. Number one, the president has limited power over certain things. A lot of immigration law, I know the applications are based upon actual statutes that the president himself cannot overturn. Those things would require a massive change through Congress. So if you're worried about the fact that VAWA is going to go away, T visa is going to go away, you can no longer do a marriage case, you don't have to worry, because those things are protected because they're literally written into the law. But what can happen is that we can see increased processing times. We can see increased scrutiny on certain cases. And for that, you just have to work with a really good attorney. You have to work with a good law firm who has been through these sorts of challenges and who can guide you every step of the way, okay? My boyfriend just applied for citizenship. Can we get married and apply for me? Do we have to announce when he becomes a citizen and changes his status from Petromalos? Petromalos, if you can get married now, because it sounds like he's probably a green card holder. So if he's applied for citizenship, once he becomes a citizen, he might be able to apply for you. But whether you qualify for an application for a green card is going to depend on your specific facts. So you can give us a call, 212-248-7907. Married to a U.S. citizen for more than a year on a B2 visa, do we have to wait 90 days to apply for my green card from DQ? The general rule of thumb is if you enter the U.S., if you apply for your green card within 90 days, then that can create a presumption of misrepresentation of intention for using your B. So I think usually the majority of lawyers will recommend to wait at least 90 days to avoid that presumption. My husband is on a T visa. Should I be added before January 20th from Bianca Trevino? Bianca, if your husband already got approved for a T visa, there's no reason for you to wait for anything. Just apply for your derivative status. You can give us a call for help with that, 212-248-7907. And if your husband still has a T visa in process, you can still be added right now during this process too, okay? Can I travel with my I-751 extension of 48 months to Canada from budget deals? Anyone who has filed an I-751 application, if you have the official green letter that says that it's an extension of your status, that is an official documentation. and you can work with this, you can travel with this. This is your official proof that you're still a green card holder. Now, the problem becomes that some people lose it. If you lose it, you can get a stamp in your passport by calling InfoPass. If your letter expires, then you can still get a stamp in your passport by calling InfoPass, okay? And again, anytime you travel, talk with your attorney. You're gonna need your original letter and your green card and your passport when you travel, okay? AOS through Citizen Sun just filed, awaiting for receipts. Can I be detained or deported from user? User, yes, for a lot of those, you can be both detained or deported. However, when you get your receipts and you show that your application's in process, most people are going to be willing to work with you to get your case, set over, rescheduled, or released on bond when you show that. And once you get your I-485 receipt, that's also going to put you in a period of authorized stay as well, okay? All right, everybody, that is all the time that I have for today. Thank you so much for joining me on my live. Hopefully the next time I'm not coughing so much and I'll be feeling a little bit better. But if you want to schedule a case evaluation, call us at 212-248-7907 so you can find out what your options are. It is more important now than ever to find out what immigration options you have to protect yourself, to make sure that you're going to feel some peace and security in the next few years to come, and to make sure that you're fighting for your rights, okay? My name is Moumita Rahman. Thank you for letting me share my time with you, and God bless. Bye.